Ready, start. However, insofar as the amount of monetary compensation is concerned, the High Court was of the view that future medical expenses and attendance charges had been granted on a higher side. Full stop. The amounts granted under these heads were thus reduced. Full stop. Insofar as compensation granted towards permanent disability, loss of enjoyment of life and amenities as well as towards pain and sufferings of family members came to be set aside. Full stop. As a consequence, the amount of compensation as granted by the claims tribunal came to be the amount of rupees 19 lakhs. Full stop. Consequently, it was held that the claimant was entitled to compensation of rupees 48 lakh 83,000. The appeal prepared by the claimant was thus dismissed, while the appeal prepared by the insurance company was partly allowed. Full stop. The claimant being aggrieved by the in amount of compensation as well as the refusal to enhance the amount of compensation thus come up in appeal. Ms. Harsha Tripathi, learned counsel appearing for the claimant, submitted that the High Court was not justified in the amount of compensation by rupees 19 lakhs. Full stop. There was no justification whatsoever to hold that the evidence on record was unsatisfied to support the claim for future medical expenses. Full stop. As the claimant had suffered 100% permanent disability, it was obvious that he would be required to undertake medical treatment for his entire life. Full stop. There was no justification for the High Court to have the amount of compensation under these heads. Full stop. In fact, the High Court ought to be have awarded a higher amount than that granted by the claims tribunal. Full stop. The learned counsel further submitted that the amount of rupees 3 lakhs granted towards permanent disability came to be set aside by the High Court without any justifiable reason. Full stop. Merely because compensation was granted towards loss of income, the said would not justify non-granted of compensation for permanent disability. Similarly, there was no legal basis by setting aside the amount of compensation granted towards loss of enjoyment of life and amenities as well as pain and suffering of family members. Full stop. Upon the decision of this court in K.S. Murlidhar versus R. Subralakshmi and other, and it was submitted that the claimant as well as his family members were entitled to be the granted compensation under the head family pain and sufferings. Full stop. In fact, the amount of rupees 3 lakhs as granted by the claims tribunal was on a lower side. Full stop.